Good morning, everyone.
Good morning.
The first case that is before the court on our docket today is Stepp versus Medina City School District, Board of Education. All right, is everyone ready to proceed?
Yes.
All right. The appellants may have 15 minutes and up to 5 minutes for rebuttal and 15 minutes for the appellate. Would you like to save some time?
I'll be reserving 2 minutes for rebuttal, Your Honor.
Okay, that sounds good. Thank you so much.
May it please the court, my name is Warren Grossman. I am here on behalf of the 4 individual former school board members. In dealing with public employee immunity, Chapter 2744 of the Revised Code focuses on intent to injure. And so here the immunity question is focused just on the 2 torts of defamation and false light. And on the press release only of March 22nd, 2013, just a very small focus here. In that press release, the board said, we didn't know what the amount of the reimbursement was. That's what this whole immunity argument has focused on. The evidence shows, if you look at the final state auditor's report in a quantitative sense, and if you look at Randy Stepp's deposition testimony, pages 247 to 249, in a qualitative sense, that there's no intent to make a false statement here at all. This immunity analysis really does have a very small focus. It looks only at that press release, March 22nd, 2013. We're not looking at events that occurred 4 months later, 5 months later, 7 months later. The briefing in the lower court led everyone on a wild goose chase because it dealt with things that happened 7 months after that press release. Here, we had a motion to substitute the final state auditor's report for the interim state auditor's report. This was the most important piece of evidence in this case. This auditor's report had been ordered in April of 2013, and everybody was waiting for it because the board didn't know what happened. The board was wondering what's in this $172,000. And by not ruling on the motion to substitute, this final state auditor's report was in effect not before the court. The court didn't consider that report. Again, this was the one thing everybody had been waiting for. And if the report finally came in about a week after I filed my motion for summary judgment, not only was this crucial, but the motion to substitute was unopposed. There literally was no reason whatsoever to not allow this motion to substitute, to not grant it. It goes beyond arbitrary and capricious, and it goes beyond unreasonable. There's no reason.
What additional evidence would that report have given to the court that the court didn't already have? Because the court knew the final amount, the check had already been written.
It gives a lot of, it quantifies things. It not only quantifies things, but it points things out that nobody had realized. And let me give you one example, Your Honor. It talks about how Randy Stepp would take one course per year or per semester to keep the interest going on. This I'd never realized this until I read that final state auditor's report, that what he was doing was taking one course at a time, so that, and by taking a course, by being a student, he didn't have to pay on his student loans. And that's how the board had to pay, or ended up paying, 29 years of interest.
But your argument is that the board had no idea of that information at the time that the press release went out, correct?
That is correct, but
So what's the relevance of that to that narrow, as you said, that narrow issue?
the relevance is, Your Honor, that the board knew something was wrong. In other words, when that press release went out, the board knew that Randy Stepp was claiming tuition of $172,000, and they knew that that was impossible. And this final audit makes it quantitatively clear how that is wrong. If you look at Exhibits L to Randy Stepp's deposition, you see, and this is what I was pointing out to Judge Schaefer, you see that Randy Stepp took out $20,600 in loans in 2003. If you look at Exhibit WW, which is his Ashland transcript, you see he only took 2 courses, one in the spring and one in the summer. So in other words, if you put that per course, that's $10,000 per course. That's crazy. No course costs $10,000. So what we're dealing with here, and what the evidence shows, particularly the audit, is that there's a tremendous amount of other money being spent here, not on tuition, but on food for Stepp's family, on gas, on housing for Stepp's family, and this is all in that final auditor's report. And this is, Your Honors, this is what the school board suspected when it put out that press release, that something was totally amiss. And that's why they could say we didn't know the amount, because they had been told by Randy Stepp in his emails of August 3rd and August 4th, 2011. These are the crucial emails that Stepp says, aha, you knew the amount. He was using the term tuition reimbursement. In other words, the school board thought it was paying for tuition. And that's why, 2 years later, in March of 2013, they could say, this is crazy, this doesn't make sense, and we didn't know the amount of this thing. That's why it isn't, their statement that they didn't know is not false. It's true.
Counsel, I'm going to interrupt and seek some clarification from you in regarding to who all is going to be arguing today. Is it just, are you the only one arguing, or are you going to be arguing? Okay, well, you're at 7 minutes, so you may want to...
I understand.
I don't know, that's up to you two, but I just thought I'd jump in there, okay?
I understand
Thank you.
100%. We've discussed this.
All right, that's great.
If the court below had made the proper analysis, it would have looked at the evidence we put forward of lack of intentionality. That is, we did an investigation ourselves with Jim Hudson, the treasurer. The school board hired a public relations firm, a renowned one, to help them with the press release. The school board asked many different sources for information for that press release. And the school board kept Randy Stepp in the loop in that press release, tried to include him. Twice they asked him for feedback, and in a sort of passive-aggressive way, he said, oh, no feedback at this time. So they're doing things in good faith. What's the bad faith here? The bad faith is that Randy Stepp told them in August of 2011 that he wanted sums for tuition reimbursement. And what did they end up paying for? They ended paying for family housing costs, family food, gas, incidentals, a discharged loan in bankruptcy, and 29 years of interest on the food, the housing, the gas, the incidentals. So, in a quantitative sense, from the state auditor's report, and in a qualitative sense, because Randy Stepp admits all of this in his deposition, that food money was in there, that housing money was in there. In fact, at page 247 of his deposition, he says, I could have spent this money on anything. Well, he did. So objectively, their statement that they didn't know the amount, it is completely true.
You know, as I read the brief, I was struck by the emphasis that was placed on the fact that Dr. Stepp did not share certain information. But what really struck me was the absence of anything indicating that the school board members asked the questions.
You've got to understand, this was a superintendent that they very much relied upon.
I understand that. I'm speaking from the standpoint of elected officials who are representing the district and voting on a contract. There are certain questions that one would think would be asked before.
He has a duty of good faith because he's a superintendent. Second, he had said to them in the emails, this is tuition reimbursement. Now, they obviously were thinking tuition and interest. That's it. Nobody thought they had to talk about housing costs or food costs or anything else like that because they trusted him. If I said to Mr. Greenberg, I would like, my tuition paid for, it's going to be tuition. It's not going to be pizzas that I bought for my family.
If I may, if you ask for student loan reimbursement, and if you ask for student loan reimbursement instead of tuition reimbursement, I mean, student loans were housing loans and education loans.
The loans were student loans, and you would expect them to pay for tuition. Well, you're right.
And you're at 2 minutes now left, period.
Okay.
I've tried to warn everybody.
Let me sit down and let me sit down at this point.
Do you want to present your argument, or do you want to wait for rebuttal?
Mr. Green, yes.
Thank you. You have 15 minutes.
Just a quick question about procedure. Mr. Greenberg represents an entirely different defendant. Would it be proper for him to not make an opening statement and to present any material that I have not a chance to respond to?
That's a good point. Are you going to be rebutting what he's saying about, or,
I'll just do my argument.
okay, and then you're going to be waiting your rebuttal?
Understood.
That's a good point, thank you.
Thanks, Your Honor.
I will be brief. Good morning, my name is Jonathan Greenberg, and I represent Appellant Jay Shields. Kind of dovetailing on what Mr. Roshan was talking to you about, disagreement and interpretation don't equal actual malice. So Mr. Shields is the HR director / general counsel for the school board. The record is clear that he did not sit in on any executive session, did not draft contract provisions, did not negotiate. He made statements where he said, I thought it meant the MBA reimbursement. The facts, if you'll excuse the colloquialism, are as clear as mud. 4 different groups of people thought educational reimbursement meant 4 different things. So there's no, who's right or wrong is really a red herring. What matters is what was the intent. And because he has the immunity as an employee of the state, he has that protection. There's no actual malice that can be shown by his statements. There is nothing that he's done which would direct otherwise. Dr. Stepp's interpretation that, as pointed out by the court, educational loans can mean all kinds of living expenses to get education. Tuition reimbursement is much more direct. What the tuition reimbursement for is another one of the issues that the parties didn't understand and agree on. So as far as it relates to James Shields, the comments that he made, were they defamatory, were they false light, he has to have been shown to make them actual malice or reckless disregard. And there is no evidence to that regard.
To what extent does his involvement in drafting the terms of the amendment to the contract come into play in the trial court's ruling that there are genuine issues of material fact
Your Honor,
regarding him?
the genuine issues of fact may go to what the terms of the contract are, but as it relates to him, he only has 2 claims against him, that is for defamation and the false light. So there has to be actual malice shown, not that the terms of the contract were unclear. That's a different issue. And the record is clear that the board and Dr. Stepp are the 2 people that negotiated and drafted the contract. When the board went into executive session to discuss the contract, etc., Mr. Shields was not present. So that's the response. He wasn't involved in that aspect of it. There are issues of fact that you can see clearly as it relates to the terms of the contract, but that's not the issue as it relates to Mr. Shields.
Thank you, Counsel.
Thank you very much.
May it please the court, my name is Mike Madisich on behalf of Dr. Randolph Stepp, who is with me here, sitting back. I would like to begin with a discussion about the supplemental audit report. The motion to substitute was filed, to substitute this audit report. There are a number of procedural deficiencies with the manner in which that was done, which are outlined in our brief. You had asked about what's the relevance of it. I submit there is no relevance to it. The appellants are claiming that because the supplemental audit report disclosed that Dr. Stepp's student loan reimbursement may have covered expenses like housing, etc., that they didn't know then the extent of the reimbursement, which is what they claimed in their press release. And I pause just for a moment to point out that the press release, the false statements in the press release are much broader than were discussed on during the first argument, and those are outlined in our brief as well. But with respect to that statement, the board didn't know the extent of the reimbursement. The question that was posed to the board in March of 2013 had nothing to do with the expenses within the student loan reimbursement. The question from the media was, when the board agreed to pay the cost of Dr. Stepp's past education, did you have a general idea of how large the bill would be? In response to that, the board said no, it did not know the extent of the reimbursement, did not know how large the bill would be, in other words. That was the board's argument below, and they even admitted that in their brief. We were talking about how large the bill would be, not what I'm sorry, Your Honor?
I didn't want to interrupt you, but I was still listening.
Well, I was just going to quote their brief. Plaintiff is unable to demonstrate that any board member knew they were saying something false in the press release when they declared their lack of knowledge that the contract reimbursement was to be $172,000. It has nothing to do with what's...
And that's where my question comes in. I thought that I read somewhere that this all came about because he did not take $30,000 a year for a couple of years that he was entitled to under his original 2009 contract. Did he not take some money that he was entitled to under that contract
That's absolutely right, Your Honor. It wasn't $30,000 a year, but he gave up his merit bonuses, he gave up raises. I'm sure there are a few other things I'm missing. They actually removed the position of assistant superintendent, which heaped a whole lot of additional responsibilities on Dr. Stepp, which prompted him to have the discussions with the board president, who everybody admits was the liaison for the board in contract negotiations, about amending his contract to allow coverage for student loans specifically. Specifically, they discussed student loans. Specifically, they discussed the amount, and that's even admitted in the brief, up to $175,000. They specifically discussed the exact degrees that were going to be covered: education, education administration, and educational leadership. They specifically discussed exactly how it was going to be paid through the ESC. After these discussions, the board president turned it over to General Counsel, Mr. Shields, on behalf of the board to draft the final contract language, which he did. Nobody ever came back to Dr. Stepp and said, well, no, we're not going to agree to cover this. We're not going to agree to cover that. But we have questions about this. They just passed it unanimously. And the language that was ultimately adopted clearly covers what was actually covered in the end. It said they were going to cover the costs associated with the superintendent's acquisition of past degrees as they relate to education. Everybody admits at the time they knew that Dr. Stepp had 3 past degrees related to education. Back to the, the motion to substitute, Your Honor, if I may. As I mentioned, this is the first time the argument's ever been made that, oh, we were really referring to, when we said extent, the expenses that made up that $172,000. No, none of the defendants testified below that that was their understanding, that's what they meant by that press release. There was no public controversy over what was paid or what was covered by the $172,000, what Dr. Stepp used his student loans for, which everything was entirely proper: housing, food, gas, etc. The public controversy was over the amount, $172,000. The board, Judge Moore, as you pointed out, the board never even asked Dr. Stepp what made up the $172,000. In fact, they didn't ask him anything at all. He even forwarded his emails with Susan Velchek to the board before they issued the press release that contained all of these details, and they completely ignored it. They just issued this press release that said, in effect, we didn't know anything about it. We couldn't have known anything about it because we don't receive reports of ESC expenditures, which is also false because they do. And there's testimony from the ESC in that regard. In fact, they provided the district with a report that listed the expenditure as a line item before the press release.
The money from the ESC is not part of the continuing, it's not part of the operation budget, so not part of a permanent improvement budget. That's not something that the board would see from financial statements that come from the treasurer each month.
It went to the district treasurer. McNeely testified, she's from the ESC, that she provided that particular report to the treasurer. And the treasurer's duty is to report to the board on the financial status of the district. Additionally, the ESC contract, which is signed by the board president, including the one in effect during the time of this reimbursement, specifically referenced carryover funds, and the payment was made out of the carryover funds, and that the ESC would provide a report of all expenditures of carryover funds to the district, so the board knew about that. When it claimed that it didn't have any way of knowing and it didn't know about these expenditures, that was false also.
Are you suggesting that there was a line item indicating that that payment was made from the ESC to Dr. Stepp?
No, it was made directly to the lending institution.
Or to, yeah, correct.
Which was also something they discussed in writing, making the payment from the ESC directly to the lending institution. And yes, it was a line item, the exact amount, right there. The pay listed.
That wouldn't be in the copy of the check registry, hypothetically, that the board would get each month from the treasurer, right? You wouldn't see that in the check registry because the check wasn't written out of the general fund. It came from the ESC, the city county money, that is money that the board...
I have to agree that that's probably accurate.
Yeah.
I don't know if it's accounted for in the general ledger or how it might be accounted for in
Well,
the
it's
district.
not part of the general fund.
Right.
It's yes, city county money that's through the ESC.
Right. And this is no surprise. I mean, even board member Grenfell admitted that he knew the district used ESC carryover funds in this manner to make payments on things unrelated to what traditionally ESCs paid for. In fact, the ESC superintendent testified that all the districts had carryover funds, and the ESC treasurer testified they all used them in this manner. And even the treasurer of the district knew that he himself had received reimbursements and was aware that payments had been made out of the ESC. So there was no secret payment or covert operation by Dr. Stepp to obtain this ESC.
I guess my point is, it's not the kind of a financial statement from the ESC that would be part of the board's minutes each month. That would be admitted at a board meeting each month where you look at
That's correct.
You wouldn't see that each month. The public would never know that each month because that's not something that's part of the general fund. It's not something that's part of that continuing, operating levy or a general permanent improvement fund. That's not the kind of thing you would see on a monthly basis.
I have to agree with you, and I'm sure that you know more about that than I do. But the evidence is that it was reported to the district. And I think more importantly is there is an abundance of evidence, certainly that Velchek and Shields knew exactly what this contract amendment meant. They were intimately involved, and it's detailed in our brief. But even Grenfell and Robinson and Freeman, there's an abundance of evidence that they either knew what the contract amendment meant, or that there's a high probability, they knew that there's a high probability that what they were stating in their press release was false. And this is also detailed in the brief. But first of all, Velchek's explanation, which is purportedly what they based their knowledge on, was that it was the MBA, the contract amendment was meant to cover Dr. Stepp's MBA and his PhD. Well, there were admissions by board members that Dr. Stepp didn't even have his MBA at the time they passed this contract amendment. The contract amendment referred to past degrees. There was an admission by a board member that a different part of the contract covered Dr. Stepp's MBA. So that doesn't even make sense. So it wasn't reasonable to rely on Velchek stating that she thought it was for the MBA. That will leave just the PhD, but the contract provision referred to degrees in the plural sense, past educational degrees, and they all testified they knew that there were 3 past educational degrees at the time. Probably the most significant thing is what I mentioned earlier. Before the press release even went out, Dr. Stepp sent an email to the board attaching his emails with Velchek from 2011 that laid this all out in detail. So here the board members are knowing, admittedly, that, well, her explanation that MBA doesn't make sense. That would lead to PhD, and that doesn't make sense. And here's evidence, tangible written evidence, that Velchek, their own designated liaison in contract negotiations, knew all of the details. But they didn't ask her anything about it. They didn't ask Dr. Stepp anything about it. They didn't ask either one of them anything at all about what transpired in 2011. According to defendants, Velchek said, I thought it was the MBA and the PhD, and even though that couldn't have been true, they were content to run with that. It shows that at the very least there's a high probability that they knew what they were stating was false. When you add on top of that the details of the 2011 communications between Dr. Stepp and Velchek were actually included in the very early draft of the press release, but without explanation, it disappeared from the final report. There's also substantial evidence of ill will, traditional malice analysis. While that alone isn't enough in a case like this to support a finding of malice, we cite Supreme Court authority that says it's relevant, though, in the context of facts like this. It's certainly relevant to show malice. And that includes, for example, at the exact same time, the board members admitted they're trying to distance themselves from Dr. Stepp in the context of this public controversy. They were looking for ways to terminate his employment. Board member Freeman testified that they were looking for interpretations of the contract amendment to use as leverage against Dr. Stepp. They weren't looking for the truth, what it truly meant. They were looking for an interpretation that they could use against him. Then you add in the fact that they did terminate his contract, and the trial court below said that actually violated Ohio law. They suspended him. They instituted multiple investigations with the end result in mind. It's just pretextual, the investigations. They reduced his salary. They refused him to pay. They refused to pay him merit pay under his contract. They refused to allow him to sell back vacation days. They, eventually they hired a permanent replacement for him when technically he was still the superintendent. When you put all of this stuff together, there is more than enough evidence to sustain a finding, a prima facie case, that the defendants in this case acted with malice. And how much time do I have left?
You have 2 minutes.
2 minutes? I can, just about the supplemental audit report briefly again. This court has held in the Stovey-Gardner case, the case actually cited by the appellants, that a trial court has the discretion to either consider or ignore improper Civil Rule 56 evidence when the opposing party fails to object to it, which here the court ignored it, the trial court ignored it. We will not presume that the trial court considered such improper evidence, however, unless the trial court specifically indicated that it did so when entering judgment in the case. To do otherwise would presume irregularity by the trial court. The point of that is, yeah, we didn't object, but the trial court didn't consider it. So it's not a matter of waiver. This court has said, under those exact circumstances, that this court can't consider that audit report. I mean, it's clearly irrelevant, but it shouldn't be an issue anyways. Just a final thing, maybe on subject matter jurisdiction. It was an issue raised for the first time by appellants claiming that because Dr. Stepp did not go through with the termination proceedings under 3319.16, that somehow the trial court lacked jurisdiction to consider its breach of contract claim. All of the case law that we cite supports that position, that they constructively or effectively or actually terminated him before any proceedings were even started. They breached the contract by not following those proceedings and took all of those actions I described earlier to force him out of office. There's case law that says under those circumstances, you're not forced to just go through the motions of a 3319.16 hearing. Moreover, there's case law that says you don't have to do so when it would be a futile act. And here, months before they ever instituted those proceedings, they admitted they were already looking for ways to terminate his position. Even as we got up to those proceedings, Defendant Robinson claimed that, yeah, we were getting ready for the proceedings, we were marshaling our evidence, we were prepared to present our evidence as to why Dr. Stepp should be terminated. Yet, the judge is the jury in that, the board is the jury in such a case. In those circumstances, and there's case law supporting it, it would be a futile act and there's no need to go through it anyway.
But if they did go through the administrative hearing and he was unsatisfied with the result, he did have somewhere else he could go after that, right?
He could appeal. Sure, that's one route you can take.
To the trial court.
Right. But the two reasons he didn't have to do that, which is supported by the case law, is because he was already effectively terminated. And two, it was still a futile act. And three, the remedy provided in the statute is reinstatement and back pay, which under the circumstances, that's not an effective remedy for Dr. Stepp to go back to work for these same people.
Thank you, Counsel.
Thank you.
The court will take the matter under advisement and issue a written opinion, which will be sent to both sides, and we also release on our website and the Supreme Court website, so you can look at our opinions electronically. Thank you very much, and thank you all for coming to court today in Akron.